financials add up, managing their budgets, and developing plans and policies that can help grow their business. All right, so without further ado, let's get started. So we first take a look at the agenda of today. So we're going to cover actually quite a bit of stuff, a lot of topics. So so today we are going to talk about estate planning and why it is important. And we will also take a look at some strategies and tools you might want to consider as you work through your estate planning process. As I mentioned earlier, if you have any questions, you can save it to the end or post them in our chat box, and I'll try to answer them at the end of this presentation. So, estate planning. So what is it? What's estate planning? Well, basically, estate planning is an arrangement of your financial affairs designed to accomplish a few essential financial objectives, both during your lifetime and on your death. Now, the plan itself should be able to accomplish the following goals for you, and that may include to provide tax-efficient income during your lifetime, before and after your retirement, to provide tax-efficient dependent support after your passing, to provide tax-efficient transfer of your wealth upon death, and may also be able to protect your assets. So by and large, estate planning is the process of creating a plan to distribute assets, a plan to take care of the people and things that is important to you during your life or upon your death. An estate plan should also include some contingency arrangement for the possibility that you may not be able to make some decision at some point in your life, for example, because of severe injury or medical conditions. So why do we need actually to carry out an estate plan? Why do we do it? Well, an estate plan will help ensure that your dependents or your beneficiaries will have the income and assets for their ongoing needs when you're not around. Because the loss of our income when you're not around means that some planning needs to be in place as a replacement. You likely would like to wish your dependents to maintain their normal spending patterns without substantially changing their lifestyle when you're no longer there to contribute to the income. That's another reason why we do estate planning, which is to minimize and hopefully to avoid some family disputes. By planning ahead, you can anticipate some issue and discuss the reasoning behind your decisions with your family members ahead of time. An estate plan would enable you to convey your wish about how you wish your affairs to be administered, including the guardians for your children. If you do not convey your wish, other people such as the government, the courts, or someone you may not really trust may be able to make decisions for you when you're not around. However, those decisions may not necessarily be agreed upon by you. So an estate plan will also be able to help minimize any costs or taxes that may arise upon death. So therefore, more property may possibly be passed over to your heirs, to your beneficiaries, rather than being eroded by some administrative fees or taxation by the government. So finally, there is a peace of mind in having an estate plan in place, as there is some certain level of satisfaction that comes along from putting one's affair in order. Estate planning is indeed the most effective way to provide for your loved ones and friends. So, what are some key components for your estate plan? Well, some key components of estate plan might include a proper drafted will. The will is indeed the most essential component of your estate plan. It might also include some insurance arrangement, including some life insurance, key personal insurance, critical critical illness insurance and disability insurance that may help provide some dependent support or to finance any tax liabilities on your death. Other arrangements may also include setting up a trust or doing some trust arrangements, such as a spousal trust or family trust that can actually hold some shares for the benefit of others while they are controlled by a trustee. These arrangements are primary goals to achieve income splitting and sometimes also be able to achieve what we call a multiplication of a tax-free capital gain exemption among the family members and between generations. When a business is actually a key family asset, a shareholder agreement should also be considered, because a shareholder agreement is a piece of document that will govern the activities of your business for the current and future shareholders. Okay, such as by addressing when to determine the business, when to sell the business, what happened when the key shareholders or any shareholder pass away, what happened when there is some life-changing event happen, such as divorce or health extraction happen to the shareholders. So all these are the key components for estate planning. So let's take a look at the estate planning process. Okay, so from the financial perspective, we first need to determine our objectives. Okay, generally speaking, the objective will oftentimes will focus on preserving and directing the distribution of your asset while trying to reduce the tax liability, or ensuring that there will be enough cash or funding to meet the ongoing needs of the beneficiaries. Now, at the beginning of the estate planning process, you will need to examine the complete picture of your current financial situation, and also to identify the assets and the form of ownership, such as should I be holding all my assets as usual, as having myself as being the sole owner of my assets? Should I actually set up some kind of joint ownership structure, having a joint account in the bank, or should I be passing on some share of my business to the next generation early, or until the day comes? We could also be considering buying a life insurance, because the life insurance process may be able to pass on to the beneficiary tax-free. The life insurance process may also be able to help you finance some of the expenses that will arise at the time of your passing. So there are many different ways to structure your estate plan, and today we'll be touch on some of those. We'll go to quickly go over some of those plans or strategies, and hopefully you will find them helpful for your estate planning. So, as I mentioned earlier, there are several ways to do estate plans. A few major ones will be the one that you're seeing on the screen right now. Okay, that could be, you could be using a power of attorney known as a POA. You could make a will. You could exercise the joint accounts to hold assets jointly with someone else. Before passing, you could also consider gifting some of the assets to someone that you care of. You could also arrange for some trust or purchase life insurance. So let's take a closer look at each one of them. So the first one we can look at is called powers of attorney, known as a POA. So what is a power of attorney? Well, I'm sure that many of you might already heard of this term. So the power of attorney, or POA, is basically a legal document that gives someone else the right to act on your behalf. Excuse me. So while this power of attorney is actually quite useful, it is also a powerful document that it actually means that you has provide or donate your power to someone else acting on your behalf, as if you were making the decision yourself. Now, each province in Canada has its own laws that governs the POA. So before you actually draft up a POA, it's highly recommended that you consult with your legal counsel in your province. Assume that most of the attendees today reside in the province of BC. But anyways, as I mentioned earlier, it is important that you talk to your legal counsel before you draft up a POA. Now, the POA itself, the power of attorney, will lose its power or will become invalid when the person giving out the power, who we oftentimes refer as a donor, dies. Okay, so when that person dies, the power of attorney can no longer be in effect. Okay, indeed, when someone passes away, it will be the executor or the executress, in the case of a female person executing the will, to carry out the deceased wishes under the will. Okay, so that's the difference between the power of attorney, which is used when someone is still alive, and a will is used when someone is passed away, and the executor or executress will be the person who carry out the will for the deceased. So when will a power of attorney become handy or useful? Well, the power of attorney is actually, oftentimes you see that it's actually useful when someone faces a health crisis, leaving that person unable to handle the business side of his or her life, such as for managing the money, paying bills, or making some key life decisions. So sometimes even you're going on an extended vacation or a trip, you could also give someone a power of attorney to look after your house. Now, the power of attorney can also be made for a specific period of time. Okay, meaning that you can specify in your power of attorney that the power will only last for a certain period of time. Okay, it may or at a time when you cancel the power of attorney. Now, there are two types of power of attorney, generally speaking. One is called a general power of attorney that would give the attorney the authority to do anything the donor could do themselves. The other type of power of attorney is called a specific power of attorney, and that is to give the attorney the authority to act for a particular purpose, such as on a particular transaction. When you want to buy or sell a particular piece of property, you will give a specific power of attorney to someone else to execute or to finish that transaction for you. And beside the general and specific power of attorney, the power of attorney generally could be used for two different type purposes. One is called one of them is for the use of for property, which is to appoint an individual who is financially capable to look after the property for you. Now, the other one, the other type of power of attorney is for healthcare decision, and it's sometimes called a living will. So what is a power of attorney for healthcare decision? Well, it is a document that you write down what you want to happen to you if you become ill and can't really communicate your wishes about treatment. So for example, it is actually quite common for people to write a living will saying that they do not want to be kept alive on artificial life support if they have no hope of recovery. However, on the other hand, it could also be used to say that active efforts should be made to prolong that person's life as long as possible. So as you can see, the power of attorney actually give a lot of power to the person who acting on behalf of the donor. So it is quite important that you should find someone who has an objective and impartial mind, and also with a rational mind to carry out this power of attorney for you, because that person will have to make some decision, oftentimes some tough decisions for you. So before we discuss the importance of preparing a will, let's take a look at what happens when you pass away without a will. So if you pass away without will, that's what we refer as pass away intestated. then the government will actually distribute your assets according to a preset formula. Okay. Now it takes some time for the court to first appoint an executor until the asset will before the asset of the deceased can be distributed out to the beneficiary. So therefore, without will, your asset upon passing will be frozen by the court, and sometimes it takes quite a bit of time before the assets are unfrozen and be able to be distributed out to the beneficiary according to the ruling of the court. So, assets that are distributed without a will may also meaning that sometimes it will create some tax consequences. Sometimes the asset will have to distribute it after the final tax bill of the deceased have been settled by the COA with the COA. It will leave the court have no recourse but by liquidating your assets in order to settle your final tax bill with the COA. And also without a will in place, the way the assets are divided between spouse and children by a Canadian province will be different from province to province. However, generally speaking, spouse will get all the assets if they don't have any children. But if they do have children, they will likely get a portion of that. The children will get a portion of that. For example, in Ontario, if you pass away without will and have let's say one spouse and two children, then your spouse will first receive $200,000 of the total assets, and then because of three beneficiaries, in this case the spouse and two children, right? So the spouse will first receive $200,000 from the assets pool, and then the remaining asset will get divided by three into three parts, and then the spouse will get 1/3 of the residual assets, with the children to receive another 1/3 each of the remaining assets. So in other words, without will, you basically are leaving everything you have worked for to the governments to divide upon. Okay, the assets that are distributed to your heirs may also result in some heavy tax consequences without a proper planning or without will. So, if you do want to make a will, what do you need to be aware of? Well, making a will ensure that your final wish will get carried out in a more cost-effective and equitable manner. It is important that you have a will regardless of your stage of life, okay, especially after major events in life, such as getting married or giving birth to a child. Okay, then having a will become more important. Now, the general rule is that it is advisable to hire a lawyer to draft up a will for you. Okay, is it required to have a lawyer to draft up a will for you? No, you could draft up a will yourself. However, it is highly recommended that you consult with some professional legal counsel when you draft up the will for you. For a couple of reasons. One, the family law or the estate law in different provinces in Canada are different. Okay, and lawyers who specialize in estate planning, they do have the expertise and experience to draft a will for your best interest. It is also usually a good idea to tell your family members about your plan. Okay, you don't need to mention about the numbers if you don't want to. Okay, however, it is highly recommended you have that open discussion with your family members. Although that it is always tough things to do. Okay, and also finally, because a will should change if circumstances in your life changes. So it is recommended you should revisit your will or estate plan every 3 to 5 years, or after every significant life event happened to you, and update your will accordingly. So next, what's important in the will? Well, as I mentioned earlier, it is important. It is an important step to selecting a right executor or executress in this case of a female executor for your will, because the executor is the person who's responsible for executing your will. So this is not an honorable position. Okay, so it is important to make sure that you select a capable person to be executor, and also that person has made an agreement in advance, because you cannot just simply appoint someone without that person's agreement in advance to become your executor, because that person does have all his or her rights to turn down this request. Okay, so up to now, I think we covered the will and the power of attorney, and we're going to switch gear and take a look at some tax implications when someone passes away. So when many people, they don't really know is that once you pass away, the Canada Revenue Agency, the COA, will treat all your capital property as it were disposed of at fair market values, unless it was transferred to your spouse. Meaning that if any asset that you held at death will be deemed disposed of fair market value, even though you have not really disposed of them, you have not sold them, unless that you have a surviving spouse, and you could then exercise a special tax provision to transfer your asset or the estate assets to the spouse at a rollover basis, meaning that you transfer them at cost. So therefore, that transfer will not result in any immediate tax consequences. Now, the capital public that can be transferred over or get deemed disposed of fair market value can include your cottage, your investment in your stock portfolio, your bonds, your mutual funds, and any other real estate. Okay, now if your capital property has increased in value since the time you acquire them, your estate may then be forced to pay some really heavy tax bill, and which can reduce how much assets can possibly be transferred over to your beneficiaries. And also, as upon someone's passing, that the deceased will still need to file what we call a final tax return, okay, to fulfill its final tax obligation. The filing deadline for the final tax returns would depend on when the deceased passing was. So if one passed away between January and October, the due date will be as usual, which will be on April 30th of the following year. However, if someone passed away in the month of November or December in that year, then you actually get a bit more time to take care of the tax return, and the due date will be within the 6 months from the day of passing. Okay, so it won't be on April 30th of the following year. However, if the deceased was a self-employed individual, or the spouse was a self-employed individual, then the deceased will actually have up to June 15 of the following year to file his or her final tax return. Now, when someone passes away, the passing or dying can be really expensive, because there will be a lot of expenses. There will be administrative expenses, expense related to your funeral. You might need someone else will need to help you to pay off some outstanding debts, such as mortgage or any financing debts that you might own to the bank. As I mentioned earlier, the deceased will also have the final tax bill for his or her final income tax return. There will be expenses related to maintenance and welfare expenses of the deceased family. Okay, and one more thing is about the probate fees, or some people call it probate tax. So some people may not be quite familiar what is really a probate fees or probate tax. Well, probate is actually a process of establishing a valid will and the authority of the executor. So the probate tax are generally involved when someone dies without a will, or when an estate includes will estate, asset held by the banks, and the government bonds. So the probate fee itself is actually the fee itself is different from province to province. I think in BC, on average, you're looking at about 1.4% of your asset at death. That would equate to the probate fees you may be faced. However, in the province of Quebec, it is my understanding that there's no probate fees. So there are ways that that we could actually do some estate planning to avoid or minimize the probate fees, such as you could set up a joint account when you're alive to have another person to share the ownership of the asset. You could set up a trust, such as a family trust or spousal trust, or you could put in money in the RSP or purchase life insurance, because all the RSP and life insurance are not subject to probate. So let's take a look at the joint ownership approach. So joint ownership. Basically, joint ownership is just to register your asset under multiple owners structure. Okay, it is perhaps one of the simplest way to transfer assets without paying any probate fees or probate tax. So when one party passes away, the ownership of this jointly owned asset will automatically transfer over to the surviving party. Now, while it is quite useful, it is a useful way to avoid probate fees. The joint ownership structure may actually has its own tax and legal issues. Okay, and especially that you must be really comfortable that someone else have access and control over your asset. Okay, and if you are a resident of the province of Quebec, you cannot use this joint ownership structure to avoid probate fees, because first of all, there's no probate fees in Quebec, and two, what we call the joint tenancy with right of survivorship agreement does not exist under the Quebec law. So there's no such thing saying that if you pass away in the province of Quebec as a resident of the province of Quebec, your asset will automatically transfer over to the surviving spouse or the surviving party under a joint ownership structure. That doesn't work in Quebec. Another way to avoid probate fees or avoid the deemed disposition of asset at death that would trigger a heavy tax bill is by giving your assets before death while you are still alive. Okay, gifting asset is perhaps the easiest way because you just simply have to give out your assets as a gift to someone that you want to give to. However, you do need to keep in mind that by gifting assets before death, although it might help avoid the probate fee, it may actually create some income tax liabilities for you at the time of gifting. Okay. For example, if the assets being gifted is a capital property, such as a rental property. Okay. This rental property will then be deemed, excuse me, to have been disposed of at fair market value and may trigger a capital gain tax upon gifting. Okay. Now, another tax implication that you should be aware of surrounding gifting is to transfer money to children. Okay. Now, if you transfer money to an adult child, then that should be okay. Okay. Unless you're transferring like a stocks or some marketable securities to children, then as I mentioned earlier, that transfer or that gifting of the marketable securities may result in a deemed disposition of the asset at fair market value and may trigger some income tax to you. However, when you actually gifting money to a minor child, okay, or grandchild, okay, then this gifting will trigger what we call an attribution of income to you. What it means is if you, let's say, give the money to a minor grandchild who is under the age of legal adult age, then the first generation investment income that is generated out from this money will be attributed back to you, meaning that it won't be taxed in the hand of that grandchildren. Okay, it will actually be taxed in the hand of you, the one who gives out this money as a gift. Okay, however, the second generation income will not be subject to this attribution rules. Okay, so it is actually quite a complex income tax issue that one should consider when you consider gifting assets to someone while you're still alive. Excuse me. Excuse me. Another strategy to sorry, 1 second. Now clean up my throat. Excuse me. Another strategy to avoid probate fee is through a arrangement of setting up a trust. So a trust is really similar to a will, because both will and a trust is designated to allow you to transfer assets to your heir or to your beneficiaries. Now, the role of a trustee of a trust and the executor of a will are very similar. They are each appointed by you, and each of them are responsible for managing and distributing your assets to your heirs and to your beneficiaries. How the assets of a trust are managed and distributed will be entirely up to you by including the terms in the creation of the trust document or the trust deed. Okay, so generally speaking, if you have a significant amount of assets, such as between the value of 150,000 to 200,000, it might be worth to consider of setting a trust. Now, a trust itself is a legal entity that it can be created to hold different type of assets. Okay, a trust that created while you're still alive, we call it inter vivo trust, and the one that created upon death through your will is called a testamentary trust. So once you transfer your asset to the trust will then becomes the legal owner, okay, of the asset, and the trustee, okay, who is someone that you appoint to, will become responsible for managing the assets being held in the trust. And that's the reason why any asset you got transferred over to the trust while still alive will not be subject to probate, because the trust itself would have become the owner or the legal owner of the asset, not the deceased anymore. And then next, you could take a look at the benefits of a trust. So now you might actually want to consider establishing a trust if your intention is to ensure that your assets are managed for the benefits of your beneficiaries. For example, this could be an important consideration if the beneficiaries are a minor child, and he or she will likely not be able to have any experience of managing their money. So in that case, you might actually want to consider setting a trust for them. So, and having a appointed trustee to manage the money for them, help them to make investment using the assets held in the trust, and also the trustee will decide when and how much income according to the trust documents, in the terms in the trust document, to distribute out to the beneficiary for the living. Now, you as a person who donate the asset to the trust to still have some control over the asset of the trust by appointing the right trustee. Okay, so it's not that you completely lose control. Okay, you could still exercise some level of control. Now, however, because a trust itself is a legal entity, okay, so it would actually help show any assets now being held under the trust from the creditors. Okay, it might also be able to generate some opportunity to reduce taxes by splitting the income to different beneficiaries under the trust. Okay, the asset held under trust is also considered as a private. It has some privacy that it does not need to be disclosed to anyone else except to the beneficiary of the trust. Now, as I mentioned earlier, because a trust itself is a legal entity, so as a legal entity, legal separate entity, the trust itself will need to file its own annual income tax return, just like an individual or corporation as a legal entity will need to file its own trust tax return on an annual basis. The filing deadline for the trust income tax return will be within 90 days from the day of the end of the taxation year. And also in any year after 2020, starting from 2021 and later years, it is required to provide additional information when the trust return is filed with the CLA, especially for non-resident trusts. So you should always factor in this trust tax filing requirements and additional accounting fees into account when you consider setting a trust for your beneficiaries. So next we take a look at the life insurance. So life insurance is also another effective way to transfer your wealth on a tax-free basis, okay, from a parent to a child or a grandchild. This is not now. This session here is not intended to provide a life insurance education session. Okay, I'm not an insurance broker. However, this session is just simply to provide you with some additional information surrounding life insurance. For the purpose of this presentation, I think someone actually mute themselves. Okay, so for the purpose of this presentation today, I just want to share two key messages about life insurance with you. The first, the proceeds from life insurance are paid out tax-free to your beneficiary, okay, and can avoid probate tax. And the second point I want to share with you is that life insurance proceeds are typically used for some or all of the following purposes. It can be used to maintain the lifestyle of your dependents, for example, your wife, your husband and children and their home, their lifestyle, and also the life insurance process can help fund their education. The life insurance process can also help pay for any expense related to your funeral, as well as to pay for any estate income taxes. Now, in addition to life insurance, you might also want to consider purchasing critical illness insurance and other type of disability insurance that will be good to have if for any unexpected life events such as a mild stroke or any long-terminal cancer, because a critical illness insurance or disability insurance should be able to provide you with some short-term relief on financial stress due to illness or other critical health issue that you might face during your lifetime. And also you could purchase a critical illness insurance before you purchase a life insurance. So, what kind of tax-specific tips or takeaway from today's presentation? Well, we should always have an annual review of our estate plans. As I mentioned earlier, the estate plan should not be static. It should be dynamic because your circumstances will be changing over time. There could be some life-changing events happen. So you should review your estate plan, suggest 3 to 5 years, once every 3 to 5 years, and make some updates accordingly. You can consider freezing the value of your asset for tax purposes. Okay, by freezing the value, it does not mean that your assets will be frozen and cannot get access to them. No. Okay, by freezing the value of your asset for tax purposes, you will be able to lock in the value of your assets today. So therefore, upon passing, you will not you will be able to minimize your final tax bill that may result from deemed disposition of your asset at death. You can consider purchasing life insurance to help cover any estimated income tax liability from your final tax bill. You could do some tax planning. You could do some estate freeze. If that will especially important for people, they might be running their own business. You could actually freeze the value of your business today and pass on the share of your business to the next generation without resulting in any immediate tax consequences. Okay, and you should also weigh the tax and non-tax benefits of using a trust or any postmortem planning. So another thing that you should also consider as another takeaway, as we mentioned earlier in our presentation today, is that if you should consider of having a power attorney. Okay, you should always maintain an up-to-date will. You should carefully select the right person to be your executor. Have that person agreement in advance to become your executor. You should also try to avoid and minimize any estate tax or probate tax by exercising some good estate planning in advance of time. So now estate planning is definitely a complicated and complex. However, on the screen right now, I'm sharing with you some useful tools and resources. You should be able to find more information about estate planning, wills, issue at death, power attorney, etc. from the following two links on the screen here. In case you want to take a picture, I just pause here for a few more seconds. Okay, so I think now that comes to the end of today's presentation, and I open for questions and discussion. And lastly, I just want to put down this disclaimer here on the screen. Okay. So I think that concludes my presentation today, and I will see if anyone has any questions, and I'll try to answer them.
Lawrence, there's a few questions in the chat. If you can open that, you'll see them.
Let me see how I could do this.
And just to let everyone know, I don't believe we sent the slides ahead of time, but everyone who has attended today will receive the slides, so they'll get that information. And we've also recorded it, and the session we will post on YouTube. It will be there for 1 week.
Yeah, I tried to.
That looks like a nice picture of your family.
Oh, that's my kid. I tried to look up the questions, but I just don't see. Maybe you know what? If you could take control, you share your screen. Maybe I could kind of look at it from there.
The questions?
Yes.
Oh, well, I'll pop them up here.
Sure.
This one is my current will includes a nomination of committee. And what is this?
The will be what?
It includes a nomination of committee. I'm
Mm.
not sure. I haven't heard of that myself. So
Yeah, I'm not sure what that really means. I assume that it means that either the beneficiary or the executor can that be an organization rather than an individual. It is to now. I don't practice estate law. Okay, so first of all, I still would recommend that you consult with a lawyer when you're drafting the will. However, it is my understanding that the executor of the will could possibly be a non-individual, meaning that it could be an organization. It's just that that organization may carry out or execute the will for you. However, as I mentioned earlier in my presentation, every province has its own estate and family law. So again, given the fact that I'm not a tax lawyer, nor a estate lawyer, I still would recommend you to consult with your legal counsel.
okay, the next one was my current will is 20 years old. I assume it's still valid no matter when it was done.
It is my understanding. Again, these are all legal questions, but however, it is my understanding that the will stay valid unless you change the will or cancel your will.
Okay. And then is a living will called a representation agreement in BC?
I'm not sure about that. My understanding is a living will is oftentimes referred as a power of attorney. That's why, and the reason why they call it living will, not a will for the deceased, is because the power of attorney is only valid when the donor, the person giving out the power to the attorney, is still alive. That's why it's called a living will.
Well, I've signed not myself, my mother signed a representation agreement, and that is something to do with the end of life care, and you usually need to engage your doctor to sign that. And is a living will a separate document?
So again, I cannot answer this question. I think maybe I should be more specific that I'm an accountant or a tax advisor. So this estate planning seminar is more focused on estate planning than legal issues. So again, I try to refrain myself from providing too much of the legal advice.
And another question is, how should I deal with U.S. property?
That's a good question. So the U.S. property for now that this I can answer. So again, assuming this question is surrounding the income tax implication holding a foreign asset or foreign property. So as a Canadian tax resident, when you pass away, your worldwide income and your worldwide asset will also get deemed disposed of at fair market value. That said, the property held in the U.S. May actually have two issues. One, because it's actually situated in the soil of the U.S. You might actually firstly talk to your U.S. advisor because at any point in time, a person can only be a resident of Canada or being a tax resident of the U.S. You cannot being a resident of both jurisdictions at the same time. So assuming that at the time of passing, you are considered as a resident of Canada, then the property held in the U.S. may be subject to U.S. tax as a non-resident of U.S. holding a U.S. property on the U.S. soil. So that means that that property may also get deemed disposed of at fair market value in the U.S. And there could be also withholding tax from the disposition that need to be remitted to the U.S. government, the IRS. So to avoid double taxation, the Canada and the U.S. have a tax treaty in place saying that, look, if a Canadian resident passes away in Canada, the tax that this person may have paid to the U.S. IRS or the U.S. government may actually be claimed on this Canadian deceased taxpayer Canadian tax return. So therefore, they don't have to pay tax again. So that's just to avoid double taxation. So again, to answer this question, I would recommend that the person holding a U.S. property should talk to the U.S. tax advisor to do some tax planning, whether he or she should actually sell this property before passing, or should they actually have some funds set aside in case that this property will get deemed disposed of at fair market value upon passing in the States.
Okay, thank you for that one. Someone's asked another insurance question about if you know at what age can you no longer purchase life insurance? It seems that there is a
I
cutoff
see.
date.
I don't think there's a cutoff. I don't think it's mainly on the age. I think it's mainly on your health condition too, right? So I could be, at the age of 40s, but if I have some pre-existing condition, I will already get rejected by the insurance company. So I think it's not just looking at the age. Although there's yes, I'm aware of that some insurance company will simply not taking on new life insurance application if the applicant has reached the age of, let's say, 70 or 75. However, I think by all means, it all goes down to the health condition or the pre-existing condition of the applicant.
Okay. And what are the tax and legal issues with respect to joint ownership?
So I think for the legal issue, I think I had mentioned earlier, when you have a joint ownership, for example, if simply put, let's say you have a joint account with your bank, that means that someone else will have access to your joint account. They have access to the cash in your bank account. So you do share that ownership with someone else. And for tax purposes, make it easier. If let's say the joint ownership is actually with your spouse. Okay, by spouse, I also include common law partners. Okay, if someone passed away and holding a joint account with the surviving spouse, then the under joint ownership structure, that bank account or any asset held in this account will get passed over or transferred over to the surviving spouse without triggering any tax implication. Okay, so the surviving spouse will be able to take over the deceased asset at a cost basis, at a rollover under rollover provision in the Income Tax Act. Now, however, it is important to note that this rollover at cost provision will only apply if the surviving spouse has the absolute right of ownership, meaning that there's no other event could possibly challenge that the surviving spouse have the absolute ownership of the joint account or the absolute ownership of the asset held by the deceased. Okay.
Okay, great. That I don't see any more questions. Oh wait, it says, what if your joint owner is a son or daughter?
Then in that case it could also be roll over. Usually it would get passed over to the joint owner. Now there could be different type of asset. So usually the rollover provision only applies to spouse and to the common law partner. When you have an asset, let's say a real estate property, jointly owned by you and your adult child, let's say, okay. There is no rollover provision to roll over to transfer your 50% ownership to your adult child tax free. Okay. However, under joint ownership structure for the real estate property, you might be able to avoid the probate fee and also be able to avoid in BC what we have something called the property transfer tax. Okay, because the child will be able to basically take over the legal ownership of your property under joint ownership structure. Okay, but not the beneficial ownership. For income tax purposes, we always look at the beneficial ownership, but not the legal ownership.
Okay, that's great. Thank you for answering all those questions. And I thank you again for putting on this presentation today for us. And like I said, the slides will be sent to everyone who attended. I personally found it very interesting. I'm interested in the family trust, so I'll have to get more information on that. And then today we also drew from the number of people who attended, and the winner of there's a game board that we'll send to you is, I don't know the full name, but the person is Moya, and I believe there's 2 people with Moya.
Moya was waving her head.
we'll connect with you and make sure you get the prize for today. So once again, I thank you, Lawrence. It's very informative.
You're welcome.
Thank you, everyone.
Okay. Thank you.
Okay. Good night.
Bye
Have a good
now.
evening.
Bye-bye.
Bye.